Hello, my name is Howard Levine. I am a partner at Finnegan Henderson and represented Eli Lilly and Company in the Ariad v. Lilly litigation. At issue in this case were two of Lilly's drugs, Evista for the treatment of osteoporosis and prevention of breast cancer, and Xigris for the treatment of sepsis. Although these two drugs had been in development for years, Ariad demanded that Lilly pay it royalties in connection with Ariad's patent, U.S. patent number 6410516. Lilly refused, and after a trial in front of a jury, the jury awarded Ariad some $65 million in damages. A panel of 3 judges on the Federal Circuit reversed, holding that the claims at issue failed to satisfy the written description requirement. The written description requirement ensures that the inventor actually invented the claimed subject matter. In undertaking this analysis, the Federal Circuit examined the claims of Ariad's 516 patent and noted that the claims cover the use of all substances that achieve the desired result of inhibiting NF-kappa B activity. But although the claims were extremely broad, the patent disclosed very little. The court specifically stated, the 516 patent discloses no working or even prophetic examples of methods that reduce NF-kappa B activity, and no completed synthesis of any of the molecules prophesized to be capable of reducing NF-kappa B activity. As such, the Federal Circuit explained that Ariad chose to assert claims that are broad far beyond the scope of the disclosure provided in the specification of the 516 patent. And the Federal Circuit held the claims invalid under the written description requirement. The case, however, did not end there. Ariad asked the entire Federal Circuit, the full court, to consider en banc whether a written description requirement even exists. The court granted the petition and asked the parties to respond to 2 questions. 1, whether 35 U.S.C. Section 112 even contains a written description requirement which is separate from enablement, and 2, if so, what is the scope and purpose of the requirement? After considering the text of the statute and the applicable Supreme Court precedent, the Federal Circuit, in a 9-2 en banc decision, agreed with Lilly that a separate written description requirement has always existed and is compelled by precedent. Further, the court explained, if the law of written description is to be changed, contrary to sound policy and the uniform holdings of this court, the settled expectations of the inventing and investing communities and PTO practice, such a decision would require good reason and would rest with Congress, not this court. In confirming the existing precedent, the Federal Circuit also made several important observations about the written description requirement. First, the court explained that the written description requirement applies to both original and amended claims, which was an issue disputed in the case. Second, the court stated the test requires an objective inquiry into the 4 corners of the specification from the perspective of a person of ordinary skill in the art, and based on that inquiry, the specification must show that the inventor actually invented the invention claimed. Third, the court stated that the written description is a question of fact and depends on the nature and scope of the claims and on the complexity and predictability of the relevant technology. Finally, in considering public policy concerns, the court further explains patents are not awarded for academic theories, no matter how groundbreaking or necessary to the later patentable inventions of others. That is no failure of the law's interpretation, but its intention. Quoting again another Supreme Court case, a patent is not a hunting license. It is not a reward for the search, but compensation for its successful conclusion. Claims to research plans, like those at issue in Ariad, impose costs on downstream research, discouraging later invention. The goal is to get the right balance, and the written description doctrine does so by giving the incentive to actual invention and not attempts to preempt the future before it has arrived. Thank you very much.